If you have been through a divorce, you need to watch this video to the very end. If you are a divorce attorney and you would like to know how to protect yourself from a potential malpractice claim because of bankruptcy, you need to watch this video all the way to the end. So let's talk about something that often happens in a divorce case where a house is involved. Usually the judge is going to say, spouse number one, you get the house. Spouse number two, you need to sign a quitclaim deed giving your interest in the house over to spouse number one. Sounds great, right? It even says so in the order from the divorce judge, right? Well, I've seen this happen a lot where nobody ever records the quitclaim deed. Now, fast forward 5 years. You know what? Let's say 10 years. Fast forward 10 years. 10 years later, after the judge ordered spouse number two to sign the deed over, they never did because they didn't know. They didn't, nobody ever gave anything to them. The procedures weren't very clear as to how and when it was going to happen. And so spouse number two has to file a Chapter 7 bankruptcy. And then the Chapter 7 trustee steps in and says, aha, I am going to take that house and I'm going to sell it because legally spouse number two still has a half interest in it. But wait, you say, we have a court order where the judge said he had to sign it over. And a trustee shouldn't be able to swoop down and claim half of it. How can they do this? Well, the answer is because nothing ever got filed. In 2026, I just checked online and it cost $25 to file a quitclaim deed in our local court. And isn't it a shame that somebody might lose 100,000, 200,000, God forbid, $300,000 or more in equity because a quitclaim deed never got recorded 10 years ago? Is the divorce attorney liable for legal malpractice because they never warned spouse number one that they needed to get the quitclaim deed recorded? Oh, maybe. Why not spend a teensy tiny bit of money and get the quitclaim deed recorded so that the spouse is protected? Right now in the state of Georgia, I see people with a ton of equity. I just got off the phone with somebody who bought a house in 2021. They have $200,000 of equity. It's been a crazy market. It is super important that the quit claim deed get recorded. If it doesn't get recorded, your house is at risk. Now, a lot of people who are filing bankruptcy will say, hey, I don't care about my ex spouse. Let's go ahead and file. I don't care what happens to them. But things change quickly when the Chapter 7 trustee moves in and tries to sell the house. Now, I get it. A lot of people think, well, that divorce happened 10 years ago. Surely this isn't an issue. And if you have children with this spouse, this is not going to be a fun day for you or the children, or especially the ex-spouse who's going to have their house sold out from under them. Now, some people say, well, I know you can't sell the house if the other person doesn't agree to it, right? Listen, the Chapter 7 trustee has special powers to liquidate any asset in your name. And so even though you may say, I don't care what happens to that ex-spouse, my first question is, do you guys have kids together? Because if you do, and are you sure? Are you sure you want to rip away their house? Because that money is going to your creditors. Are you positive? Now, to my attorney friends who work in the divorce area, and by the way, I appreciate the work you guys do. It's important work. And I know a lot of you think, well, listen, I'm a family law expert. I'm not a real estate expert. I should not have to go and record this deed. I get it. Will that hold water if you're sued? It might. Did you give enough warnings in writing? You might win if you did and you covered yourself and you gave clear instructions and you explained what was happening with the property and how it was important to get the quit claim deed signed. But wouldn't it be a whole lot easier just to walk over to that blasted courthouse and pay the $25 and get the quit claim deed recorded so you never have to worry about the hassle? I I think so. Another objection I've heard is, well, hey, look, if spouse number 2 files bankruptcy and we end up losing our equity because of their bankruptcy case, we're just going to reopen the divorce case and the divorce judge can hold them in contempt, right? Maybe they can. Is that worth banking on? Are you sure that's going to happen? Because spouse number 2 might have some pretty darn good reasons for being in a bankruptcy. A lot of people file because loss of job, car wreck, medical catastrophe. There's a million good reasons why people get in trouble. And there's an old saying, you can't squeeze blood from a turnip. So if somebody's in a chapter 7 and you're planning on suing them later and reopening a divorce case, even if the judge says you're going to have to pay it all, are they going to pay it? Probably not, because they can't. It's not possible. So protect yourself. If somebody is supposed to sign a quitclaim deed over to you because of a divorce, make sure you get it filed properly with your local courthouse in the real estate records to notify any potential buyers in the future. That is critical, key, super important. If you want some free information about Chapter 13 or Chapter 7, I've got a book online you can download for free, kellycanhelp.com. I've also got a lot of podcasts on kellybankruptcy.com. I also have a lot of YouTube videos. My handle on YouTube is Kelly Can Help, and I hope you'll check those out. And if you've got any questions at all, don't hesitate to reach out. Thank you.